For anyone who's not been to one of our webinars before, welcome. First of all, apologies for the fact that we'll mostly be talking about cake and champagne, and there will be a tiny bit of law involved in it. Anyone with any questions, please ask them as we go along or save them to the end. If you see a topic that we're discussing that has relevance to the question that you want to ask, then I always think it makes sense to ask it as we go along, and we will try and answer it in the Q&A. If you put it in the chat, we might miss it, but if you could put it in the Q&A, we will get to it. If you have any questions about anything else, then ask them at the end. That's absolutely fine, no problem. It's a sort of surgery at the end. We've got a lot of people from claimant and defendant firms. We've got insurers, we've got tour operators and airlines, we've got loads of people. So even if Andrew doesn't know the answer to your question, which is very unlikely, somebody else will, very unlikely, somebody else will, so feel free. If you want to ask a question that you want to ask anonymously, then please do, you just anonymize yourself. Otherwise, we are quite likely to name check you when we answer it, just so that we kind of wake you up so you know that we're answering your question. We are being recorded, and the webinar will go on our YouTube channel so that other people can see it. So you might want to anonymize for that reason. It doesn't tend to cramp our style, actually, Andrew and me, but we are recording, just FYI. If you want to chat, then the chat function is a really useful one. Every time we do this, we get some questions in the chat. We try and import them and try and deal with them. But as I say, questions preferably in the Q&A, because then we know that you've asked them. We're going to be dealing today, by popular demand, with the travel law cases and developments that we've seen last year. And we're also going to do a little bit of crystal ball gazing, which is the fun part for this coming year. It actually doesn't take a lot to see what we're going to see more of this year, because we're already seeing it. And to some extent, it follows on from what happened last year. But if you have your own views and your own predictions, then please chime in with them, because we want to know. We like to see what everyone else is seeing, because bear in mind that you see it before we do. As the barristers, we see claims coming through much later than you will do. So I'm going to talk a little bit, first of all, about what's happened this year in terms of developments. It's been quite a busy year, 2021. Andrew's then going to talk a little bit about some of the developments that he's been looking at and the questions that we get asked in relation to service in particular. And then we're going to talk a little bit about the holiday cases that we've seen coming through, and Andrew's going to address those. And then we'll have a think about what we predict for next year. So any questions, feel free to ask them as we go along. So the first thing that's happened, and actually this is going to be a lot of subjects that we have dealt with very, very extensively over the last couple of years, but it can't be helped. The really big thing that's happened has not been COVID, because COVID is something that only lasts, we hope, a couple of years. Brexit is something, it's the gift that keeps on giving. It's something that has completely changed the cross-border scene in terms of jurisdiction, enforcement, in terms of service, in terms of how we bring claims and how we defend them. So Brexit, I think, is the headline here. It's the most important development we've had. The exception to that, of course, is that applicable law remains the same as ever it was. So the Rome 2 regulation, which deals with tortious applicable law, and the Rome 1 regulation, which deals with contractual applicable law, both remain in force, which means that when we're looking at applicable law, we are using the same regulations that ever we did. But we are now Brussels-less. So the jurisdictional questions have now completely altered. So you are not looking at the old jurisdictional regime. I had a case the other day where I was striking out because somebody had brought proceedings in July of last year, July 2021, pleading that there was jurisdiction in the English courts because of recast Brussels. We've given a lot of webinars about this, and I would not expect that any of you guys will be doing that, but people are still bringing proceedings thinking that recast Brussels applies. It doesn't. You can't establish jurisdiction on that point, and that's just unarguable.
Yes, and some people have not kind of noticed the first three words on that slide. You know, there are still some cases where some litigants are proceeding as if that hadn't happened. Yeah,
there are. And it's really difficult to understand that, because Brexit is not a secret. It's not something that we didn't talk about. I mean, as a nation, but also as a chambers. I think as part of my prediction for next year, we're going to see some professional negligence coming through. We're already dealing with a number of professional negligence claims because of people who have missed exit day, and that has meant that they've deprived their clients of jurisdiction, because when they could have brought claims under Brussels, now they can't. And that's going to give rise to professional negligence claims, which is what we were trying to avoid when we were giving all of those Brexit talks in the run-up to exit day. But it seems that maybe some people were not listening. So we're going to see some professional negligence claims rising out of that. The government's conducting an overhaul of Euro legislation. And as part of that, and its first step in doing that, it's announced its plans to bin VNUC liability. You'll recall that VNUC liability is the road traffic insurer liability for road traffic accidents which occur on private land, for example, not on public roads, and in relation to things like mobility scooters and tractors and other sort of more esoteric forms of vehicles. That was a liability that was imposed by the Court of Justice of the European Union in VNUC, hence the name. It's something the CJEU is now rowing back from, but we are rowing back from it even more, and we'll talk about that a little bit next year. But that's what's happening in a Brexit context. As a result of Brexit and the fact that recast Brussels doesn't apply anymore, the government amended the Civil Jurisdiction and Judgments Act on jurisdiction, and they put in these new sections, section 15A to C, and these are really, really important for some claims because they provide jurisdiction in relation to some claims which were covered by recast Brussels, but which are not specifically covered by the common law rules. So if you've got a consumer contract involved or an employment contract involved, this is your go-to. In terms of jurisdiction, you are looking at whether or not your claimant is a consumer and a party to a consumer contract, because if they are, the claim can be brought in the courts of the place where the consumer is domiciled, irrespective of where the other party to the contract is domiciled. If you've got an employee and the matter relates to an employment contract, so for example, it might be a claim brought for failure to exercise reasonable care under the employment contract, then that claim can be brought in the courts for the place where the employer is domiciled or where the employee habitually carries out his duties, which gives you an absolute right to those courts taking jurisdiction if it is the courts of England and Wales. Those are really, really important provisions, which we're going to see used a lot more in the coming year. So in relation to jurisdiction, there is a saving. We haven't completely done away with recast Brussels. These are the two savings that we've kept. Chris Deacon says, to what extent do you need to prove the employment or consumer relationship under the applicable law at the point of pleading under these provisions for jurisdiction purposes? That's a really interesting question, Chris. I think the answer to that may be found in Brownlie, actually, which is that Brownlie said, well, you don't need to plead. First of all, you don't need to plead law at all under the CPR. So there is no requirement to plead law, although you may now do so. You couldn't do before the CPR came in under the old rules. Now you can plead law, but you don't have to. And Brownlie 2 in the Supreme Court, is good authority for the fact that you just plead the fact of it. So you say the applicable law, the Romanian law, or the Chinese law, whatever it is, says X about the employment contract, or says Y about the employment contract, and it's for the other party, it's for the defendant to say otherwise, and then you might have to go on and prove it. But in a pleading context, you've only got to plead the fact of it. You don't have to plead why. And we quite often get defences that say, well, you haven't pleaded the specific regulation under French law, or whatever it may be. You often see that where you have pleaded in particulars of claim, there is a direct right of action against a motor insurer under French law. We know there will be, because of the motor directives and because the French have implemented the motor directives, unlike the English. Defences sometimes come in and say, oh, well, you haven't pleaded what specific item of legislature it is that gives rise to that direct right of action. The answer to that is you don't need to. You don't need to plead law. And I think the answer is probably a notice to admit facts that says to the defendant, well, okay, we will go and get a French law report that tells us where the direct right of action comes from, but you will have to pay for that because you're raising this issue when actually we all know that it's not really an issue. So I don't think you really do need to plead it, but you need to plead the facts that give rise to it, i.e. there is a consumer contract or there is an employment contract. and this is when it was formulated, and you need to plead the consequence of that, you say, under whatever foreign law it may be.
That's what I was about to add, because there has to be the subject matter of the claim has to be the consumer contract or the employment contract. So you're going to have to be pleading the case based on those as being the factual background.
Yeah, that's right. That's right, I think. Now, other than in those contexts, so consumer and employment contexts, we are back to the old rules. So these are the old common law rules that we were using pre-Brexit for rest of the world cases. Now we're using them for cases that arise within the EU. So the starting point is that you need to apply for permission to serve the claim outside the jurisdiction. And in order to do that, the claim must be able to pass through one of the jurisdictional gateways. The claimant must state in terms that they believe the claim has a reasonable prospect of success. Now, of course, you wouldn't be bringing it if it didn't have a reasonable prospect of success, but any application that does not state that in terms is defective. The court must be satisfied that this is the proper place in which to bring the claim, so the forum convenience test. The jurisdictional gateways, the two most important ones for our purposes for today, are that damage has been or will be sustained within the jurisdiction. The CPR actually changed from when Lady Brownlie brought her claim, which we'll come on to in a moment, to, I think it changed a couple of years ago, actually. So she was well into a litigation by the time it had changed. So it is clear from the face of the CPR jurisdictional gateway now that indirect damage, so damage sustained within the jurisdiction, is enough to get you through the tort gateway. We've also had Brownlee that clarifies that it always was. The other tort gateway to bear in mind as well is anchor defendants. They have to be necessary or proper parties to the claim. We've had quite a lot of case law about that in the last couple of years. It's not enough to just anchor a claim with a defendant and then in a sort of fanciful way. It's an abusive process to do that. But also defendants who have a sort of tangential relevance to the claim can't be brought in as a result of that. There has to be a nexus there. We'll come on to that when we look at the case law from last year. So in relation to jurisdiction, there's some fun cases going through the High Court and Court of Appeal at the moment in relation to residents. Chowdhury is a High Court appeal case. Temporary presence abroad for the purposes of accessing healthcare does not mean that your claimant is not resident within England and Wales when they issue proceedings. So that is authority for the proposition that even if the claimant is not physically within England and Wales at the time the proceedings are issued, they may still be resident here. So there's a difference between physical presence and residence in England and Wales for jurisdictional purposes. And going abroad to access healthcare is one of the things that the court will look at as being relevant to why they're not physically here and whether or not they intend to return. Now, Chowdhury is subject to a permission to appeal to the Court of Appeal, and there is an application to join it with State and Cosmos, which is leapfrogging from the High Court to the Court of Appeal at the moment, because it gives rise to an important question of policy which relates to the armed forces. So if you've got a claimant who is a member of the armed forces, they are abroad for quite long periods of time, and their family may also be abroad with them, their kids may be abroad with them. And the question arises as to whether or not that means that they are still resident in the UK, or are they resident in that place abroad, or have they abandoned their residence? At first instance, the judge found that the claimant, who I think was a member of the RAF and who was in Cyprus at the time the claim was issued, was not resident in the UK, or was not resident in England and Wales at the time the claim was issued, and as a result, there was no jurisdiction. As I say, that's being appealed to the Court of Appeal, and we ought to get that, I would hope, sometime this year, although it may be delayed by the Chowdhury case. In relation to the tort gateway, of course, and pleading foreign law, as Chris says, your authority on that is, of course, Brownlee. I said that, will this be the end of the Brownlee litigation? I wouldn't bet on it. The last I heard, there was an unseemly ruckus about costs, on the enormous costs which have been incurred in relation to Brownlee, because it's gone up to the Supreme Court, gone down and gone back up again. But Lady Brownlee won at the end of the day, and she got the court to affirm or reaffirm that indirect loss is sufficient to satisfy the tort gateway. As I say, it is now anyway, because there's been an amendment to the CPR, but it was at the time that she issued. It also restates the principle in Bumper Corporation that there's a presumption that foreign law is the same as English law. So where nobody has pleaded an alternative law, you proceed on the presumption that, say, French law, if that's the applicable law, is exactly the same as English law until somebody proves otherwise. It's quite a handy evidential presumption. It can make all the difference. In Brownlee, it did make all the difference because there was a presumption that Egyptian law was the same as English law. So where you haven't got adequate evidence of foreign law, you just slide into the presumption. So in a sense, that's good for the claimant because it means that where there's a lacuna in the law, you just fill it with English law, and it's for the defendant to raise that as an issue. Now, as I said, there have been a number of cases on anchor defendants and related proceedings. ID and LU confirmed that just because the anchor defendant submits to the jurisdiction when they need not have done, or one defendant submits to the jurisdiction when they need not have done, it doesn't anchor everybody else. They can raise jurisdiction on behalf of the other defendant who's submitted. Which I think we always knew, but it has confirmed it. Tassel's interesting of historical value now only because this is in relation to the Keefe insurer anchor. So it was a question of whether or not you could bring the, let's say, driver in because you'd anchored the motor insurer. And maybe that you wouldn't anchor either now. But so historical, really, I think my preference is not to bring drivers in when you could be bringing just insurers in, because why would you? Particularly now that service is an issue, which is what Andrew will go on to deal with now.
Thanks, Sarah. Well, we do get quite a lot of questions about service and about the new Form 510 and which is the correct box to tick. And as I'm sure everybody knows, the N510 is the form you have to fill in when you're going to serve out of jurisdiction without permission. And the new form's got two parts to it. And the first part is where service is within the UK, but outside the jurisdiction, so in Scotland and Northern Ireland. So I'm going to gloss over that. And it's the second part that we're more concerned with. So this is service outside the UK. And there are several boxes which can be ticked. And these basically mirror the new provisions in CPR 6.33. So the first box is the box that you tick if the basis for saying you can serve without permission is that it's a consumer contract, as Sarah was talking about a moment ago, or if it's an employment contract. So this is the box that you tick if you're relying on the new sections 15A to C of the Civil Jurisdiction and Judgments Act 1982. So that would apply, for example, if you had an employer's liability case with the employer being overseas, provided that the criteria in the Civil Jurisdiction and Judgments Act were met. Or if you had a relevant consumer contract, one possibility might be if you had a contract for an event that had been bought here, the event taking place abroad. So that's the box that you tick if you're relying on any of these new provisions. The next box is the box for when there is a choice of court agreement within the Hague Convention. And I think for our purposes, that's really going to be very limited because this doesn't apply to personal injury claims. But there's another box for the other provision where you have a contract with a choice of jurisdiction clause that doesn't fall within the Hague Convention. And that's the case for quite a lot of the contracts that we look at. So that's the third box. And then the fourth box is a catch-all, because you tick this box saying that the court's got the power to determine this other than under the Hague Convention, and notwithstanding that the defendants outside the jurisdiction and the facts of the claim didn't occur in the jurisdiction. And this box is the box that you could use if you were relying on, say, the Athens or Montreal Conventions, which themselves provide for jurisdiction. So this is where you have some other enactment that gives the court jurisdiction and means you don't have to have an application for permission. So I think it's really the first box and the third box and the fourth box that we're mainly going to be looking at. And moving on then to, Sarah has to advance the PowerPoint. New rules on service. Well, as we all know, you can't serve on UK handling agents or foreign insurers anymore. And to do that or try and do that is a big mistake, because if you don't serve proceedings and you run out of time to do so, then that is the end of the claim, essentially. There's only very limited possibility to extend time after the time for serving has passed. And the fact that you served on a UK handling agent of a foreign insurer when that's not allowed anymore is not going to be a reason to get you an application off the ground. So it's really important to remember that, because if service is done incorrectly, then you can actually end up, well, losing the whole claim. And if we go on to CPR 6.37, this provides that the court may give directions for the method of service. And that can be quite useful if the court specifically says how the claim should be served. You can't be criticised if you follow what the court has actually ordered. And this rule provides for a variety of methods that you can serve. So serving through the FPS, service on a state, service by way of any other method permitted by the CPR or by a treaty, or any other method permitted by the law of the country in which the proceedings are to be served. So, for example, a local agent, if that's possible in the country that you're talking about. And it seems to me that the safest course in pretty much all cases is to either use the foreign process section or to serve via a locally permitted method. But of course, you've got to be very confident that the method that you're employing actually is locally permitted. And there's been some controversies about that that I'm aware of, certainly with regards to Spain, about whether or not it is possible to serve with a local agent, because certainly shortly after the end of the implementation period, I understand that there were some problems actually affecting service in Spain through local agents. What we've said on the slide here is be aware of the backlog. The importance of that is once proceedings have been issued, there is only a limited amount of time in order to effect service. So we've got the 6-month period, and that goes from the date of issue of the claim, not from the date that permission's given to serve out. So if there is any sort of delay in making the application, you can end up with a much shorter period of time for actually effecting service. So the clock starts ticking, not wanting to sound too much like Michel Barnier, once you issue the claim. So it's 6 months from then that it's before 6 months from then that the alarm clock really needs to be going off. And there are cases of foreign and secret surgery where judges have said that the starting point is that 6 months is generous and should be ample time. And if service hasn't been effected in that time, then something's gone wrong that calls for an explanation. Well, in a case like that where you are running out of time, you obviously need to make an application to extend time. That's potentially dangerous because that's made without notice, and the defendant can try and challenge it afterwards. And if a challenge is successful, then that means service hasn't been effected. So if you were issuing hard up against the limitation period, then you risk actually losing the whole claim as a result of that. So it's much better to actually manage to serve within the 6-month period rather than relying on an application. And if you do have to make an application, then I would suggest it's very important to have got all of your ducks in a row about how it is you come to be making the application, to avoid any sort of criticism about delay or not dealing with things quickly enough. And my suggestion is to think quite hard about how you're going to serve proceedings before you actually issue, so that you're not so that you're going from a standing start when you actually issue the claim. Because if you issue and then think about service, you can end up sending proceedings off to the foreign process section sometime later and potentially run out of time. And the reason we've said beware of the backlog is because Sarah and I are both aware that there has been quite a big backlog in the foreign process section. So you can find you send something off and it's not processed for several months. And It's also, you may find then that once they send it to the other jurisdiction for service, that there's also a backlog there. So you can have a multiple backlog and very easily find that almost the whole of 6 months or more is taken up with the backlog, meaning that an application is basically inevitable. If that was the position and it was basically impossible to serve within 6 months, then I anticipate there shouldn't be any problem making an application to extend. And if the defendant did try and challenge that, they'd be in some difficulty. But where there's going to be problems is where there was just about enough time and maybe a little bit of delay. And that's the situation where you've potentially got some litigation risk. And that's the situation that's best off being avoided if at all possible. So start thinking about service early on.
Yeah, I mean, there's been quite a lot of low-hanging fruit that way this year. There's been quite a lot of witness statements from people saying, yeah, I issued and then I waited 2 months before I did anything, but 4 months should have been enough for the foreign process section to have served. The courts do not like that. And there have been a number of claims struck out because people have waited a couple of months before even sending to the FPS. For things like translation, for understandable reasons, or waiting for medical reports. Claimants should not be waiting for medical reports before serving proceedings. And there's a distinction between the claim form and the particulars. If you can only serve one thing, serve the claim form, because there's a difference between the rules on claim form and particulars of claim. But there have been lots of claims struck out as a result of all of this.
But the problem with any sort of waiting to even start the process of serving is that you're making yourself a complete hostage to fortune about how long that process then takes. And in most of the reported cases where these applications have then been overturned, there's normally been a very long delay, which is unexplained. And, you know, I think the courts are going to be mindful that there's a general discretion to allow an additional time for service if you make an in-time application. And it's different to if you're making an out-of-time application where it's only very limited. And I think that the court's going to be quite careful not to import the stricter test when you've made an in-time application. But nonetheless, any sort of delays are potentially going to undermine it.
But the exception to that, an anonymous attendee says, have you come across many cases where orders to extend time have been set aside following a challenge made by a defendant? What tends to be the court's approach to such applications? The answer to that, I think, is it depends whether the limitation's expired. Because if limitation hasn't expired, there's no point making the claimant go back and reissue it and start again. If limitation has expired and they're applying for an extension of time, the courts are much more willing to strike them out because there's a point to it. Because effectively, I mean, I had one where it was an Athens case, I think. So the limitation period was 2 years and they'd awarded themselves an extra 9 months on top of the limitation period by extending time for service. And the courts are unlikely to view that as being reasonable because it sort of gets around the limitation period and the courts don't like it. So yeah, there have been loads of cases where claims have been struck out, but the only ones I've seen have involved an extension of time beyond the limitation period. And it's certainly my experience.
Yeah, because otherwise there isn't any sense really in making the challenge. Yeah, and even if it's successful, the claimants can always just start again. I mean, I say always, obviously there are costs involved in that, but not enormous costs. And I think also claims, multiple extension claims are also quite dangerous. Yeah. You know, if you've had one extension and then you apply for a second, obviously you're doubling the risk that one or other of them is going to be overturned.
Yeah, and there's got to be a really cogent reason for that.
Yeah, and there are cases where when that's then looked at again, one of the extensions is upheld and the other one isn't. Yeah. But you need to have both of them upheld for the proceedings to have been served in time.
That's right.
And this has been a massive issue with claims that were issued just before the end of the implementation period, because those claims are going to have the benefit of this jurisdiction, whereas claims afterwards not necessarily. So it's not the same as limitation, but it could have a similar effect on the claim.
I think it's similar. I think it's analogous. Nick Lucas asked, before we fall out, Nick Lucas asked, in the event of a lack of formal response following service, is a full-blown application for default judgment always required, as opposed to just sending a request form to the court, where service has been effected out of the jurisdiction? So is a full-blown application for default judgment always required, or can you just ask the courts for default judgment? I don't know the answer to that as a matter of procedure. I would have thought you could just ask the court. I've certainly seen people just ask the court and get it. I don't know, Andrew, do you know?
Well, I'm just looking at my white book, which happens to be on my knee. So if I have any more thoughts about that, then I'll let you know. Okay,
we'll get back to you, Nick. Chris Deacon asked, or somebody else could answer in the chat. Somebody will know. Somebody out there will know. There we are. We've got 4 chats. Let's see. Chris Deacon asked, have you seen much defendants failing to acknowledge service in time? So, for example, the office is not regularly attended due to COVID and seeking further time for an acknowledgement of service. I have an unconvincing example of this where we had to cave as the court would inevitably have given D additional time to file the acknowledgement of service. Sarah knows about this. I do know about this. Yeah, I mean, I think the court would, unless it's a very long time and it's very unconvincing, I can't see any circumstances in which the court would not give additional time, is the answer to that. There is a certain leniency. And I think courts kind of see the justice of they know that big companies, things get lost. So I know you're unconvinced by it, Chris, but I do think that the courts are trying to do justice there and saying, well, okay, a lot of these offices are not manned by people with experience in dealing with, say, you know, they don't have their legal counsel there when they would have done. So Mike is answering yours, Nick, so that's all good. So Andrew needn't worry. Let's have a look at the chat.
We've got a question about the timing for an application to extend. And what if we're in a situation where the FPS have said that they're going to take longer than 6 months? And should you just make an application to extend at the same time that you apply for permission to serve abroad? I've never seen that done, actually. Have you, Sarah?
Yeah, it's fine. Judges are fine with it.
But it has the same caveats as we were saying about any application like this.
It's got to be supported by evidence. So you have to put a witness statement in that says, the FPS have told me it's going to be longer, so I'm going to need more. So I thought I might as well apply now because it saves costs. And the judges are perfectly happy with that. But it's got to be supported by evidence, even if it's just an attendance note with the FPS. But the FPS are really, really good. I mean, they're really competent. So they should be able to give you a letter as well. So as long as it's evidenced, it's fine. Christine and Catherine Allen both agree you have to make an application supported by affidavit. You can't just write to the court to get default judgment. So now we know. Nick has applied for permission.
Also, if you do just write in, then there are costs reasons why you might not want to do that in a case where you've had to go to a lot of time and trouble and money to be able to serve. You wouldn't necessarily want the fixed costs in that case.
True. Nick says that he's applied for both for permission to serve out and for extension of time for service, both granted. I mean, that's my experience of it. If you've got evidence of the FPS saying it's going to take longer, you might as well apply as soon as you can, as long as you show that you're on top of it. So you're talking to the FPS, they're talking to you, getting things translated. And at the time that you make the application, you put in evidence. And then by the time of the hearing, you're able to instruct your barrister, who will inevitably be either Andrew or me, what you are doing, what you have done since the application. So you've not just made the application and then sat on it. It's quite important to keep us updated as to what's going on.
Because also, if you do make an application straight away, then that actually presentationally can look quite good, because it means that at the time you come to seek permission to serve out, so very much at the beginning, you've already thought through about service, you've already investigated it, you've already taken a lot of the steps that we were talking about to find out what's going on. So, you know, at that stage, if you already know you're going to need more than 6 months, then you definitely look like you've got your ducks in a row on that, I would say.
Yeah, I mean, Christine's pointing out that detail and evidence is key. It is. And yeah, you will get applications for extensions once without a hearing, as long as you have provided evidence that shows every step of the way that you're not delaying.
And also, with that evidence, of course, you've got to remember the full and frank disclosure, because there have been several instances where that's caused things to become unstuck in the course of the last year, as per some of our briefings that have gone out.
Yeah, that's actually a really good point, and particularly disclosing that limitation has passed. You must do that. in terms, because otherwise it's going to be a ground on which the order is going to be set aside, and not a bad one. Right, COVID. A brief word about COVID before we move on to holiday claims. I mean, this is just a list of all my favourite things to talk about: Brexit, COVID. COVID and cancellation claims under the common law. We've had quite a lot this year of, I don't know why, but I seem to get quite a lot of cases of people cancelling skiing holidays, Andrew, where they have booked accommodation and flights separately, and the accommodation contract has express contractual terms which mirror the package travel regulations often, and which provide for frustration. But as long as English law applies to the accommodation claim, then you can make a cancellation claim, but it will be subject to the 1943 Act, which means that the accommodation provider can subtract from the refund the costs associated with providing the accommodation, and that will include things like costs of mortgage on accommodation or rent, or salaries for staff, although there would then be a set-off with the furlough scheme. But so you can make you can issue proceedings in relation to cancellation in relation to one component only. In relation to the package travel regulations, there's loads of case law about this coming through and to be heard in the next year. Regulations 11, 12 and 13 and 14 in play. Alteration of contract terms, because hotels are changing because sometimes they're closed as a result of COVID, but another hotel is substituted. I've got a case that's going to appeal at the moment in relation to that. An odd case, that one, because it's actually, the judge said that he was hearing it under Regulation 12, which is termination by the traveller, and he said that substitution of one hotel for another was due to extraordinary circumstances at the place of destination, and he interpreted that as meaning the hotel. So for those purposes, for that case, the place of destination was the hotel. I think that's wrong, and I think it's clearly wrong. You all know that under Regulation 12, the cancellation or the termination has to be due to extraordinary circumstances occurring at the place of destination or interfering with carriage. There's going to be a lot of case law around that coming up next year. And Regulation 13, termination by the organiser and whether or not it is appropriate for compensation to be paid. For what it's worth, I think in COVID, it's a force majeure type situation, and I think it would be very harsh for compensation to be paid in addition to a refund, but we will see. We've had one reported case through from Scotland, which was of limited value because it talks about the standard terms as opposed to the package travel regulations, but the local authority was entitled to a full refund where a school trip was cancelled due to the pandemic. We're going to see a lot of these in the forthcoming months to come. Any news of cancellation of school claims involving overnight stays, in particular in relation to the PTRs? Yeah, as I say, we're seeing a lot of them going through. I've got a lot of them on. I know Andrew's got some on of cancellation of school trips. There is no reason, I think, why school trips should be treated in any different way to any other travel arrangements. They're very, very fact sensitive, all of these cancellation claims. But there is nothing to say that school trips come outside the regulations or should be treated in any different way. So you just look at it in an orthodox way. And a lot of them are going to be entitled to refunds, I think, for what it's worth. Then you've got the denied boarding regulations. This has been less of a problem because if the flight doesn't run, your consumer is entitled to a cancellation and that's the end of it. Airlines are largely doing it or have largely done it now after a bit of prompting by the CMA. So I think those are going to be less of a problem. Another interesting area, COVID and illness claims. Are we going to see a lot of those? I actually don't think we are going to see a lot of COVID claims in this context. We might see some flight ones. I seem to recall a flight back from Zakynthos where everybody came back down with COVID, and it seemed to be fairly clear that it was contracted on the flight. So possible to prove causation in that case, but how do you prove a breach of duty? And how do you prove what would have happened but for the flight? It may be that a defendant could say, well, you would have got COVID sooner or later anyway, just look at it, especially with Omicron coming up. So there's going to be lots of problems with COVID and illness claims to do with the nature of the duty. It's not going to be strict liability, it's going to be negligence. To do with the breach of the duty, what or the defendant to have done that they didn't do. And it's going to be a lot easier to prove there's a problem if you've got an outbreak. They're basically norovirus cases, but speeded up, because COVID is much, much more infectious than norovirus. So think norovirus. If it's a claim that probably would have succeeded had it been a norovirus, it might succeed. If not, you're going to have a problem. Or claimant's going to have a problem. And holidays, Andrew, unless anyone's got any questions about COVID. I just cantered through COVID because we're kind of a bit over COVID. We're going to see a lot more of it next year. There have been a few on cruises, that is true. But remember, Claire, this is Claire Pearson saying there have been a few COVID outbreaks on cruises. But remember the norovirus cases on cruises, they were always incredibly difficult to bring for claimants unless it was the second or third cruise. So we all remember the Van Gogh cases where I think they had 6 cruises in a row, all of which had norovirus outbreaks on them. And the first or second cruise, they had a much harder time of it trying to prove that there was a breach of duty, because once norovirus is on a cruise, it's really hard to get rid of it because it's a self-contained cruise liner. Of course, they weren't allowed to put into port. So it's only once you're onto your third or fourth cruise that it's sustainable, really, to say, well, there's something that the cruise liner could have done about it. If COVID follows that pattern, then I think it's going to be very difficult for claimants to bring claims, because cruising just came to a standstill quite early on in this. Tony's just asking, is the UK tour operator obliged to provide a refund if the passenger is living in an alternative country, booked via a UK travel agent, subject to a quarantine restriction in their European holiday destination, and can no longer travel? Okay, so if there is a quarantine restriction in the European holiday destination, I think at first blush what I want to say about that is that it's going to affect the performance of the package. And if that's right, then a refund is going to be payable. Andrew, I know you've done some cases on this.
Well, yeah, so I think what's unusual in this situation is that we always think about UK package travel contracts being about people from the UK going to other countries, yes, whereas this is actually inverted, and the place of destination is the UK rather than Zimbabwe. And it seems to me this would be the same as if there's something going on, let's say the holiday to France, and that there's something happening in France that makes the holiday very difficult to perform. And, you know, in the same way that you might well expect a different result if you've got quarantine in France to if the holiday's in trouble because of quarantine in England when you come back. This situation is analogous to the holiday in France. So I would agree with Sarah.
Sorry, I'm just disagreeing with Nick Parkinson on the chat.
Well, the good thing is that we're all able to look at this slide, which I absolutely love. And, you know, so much about it. It just really makes me just realise how much we've all been missing in the past 2 years when we haven't been able to travel so much.
How true. How very true. Right, let's do some law, Andrew.
Oh, okay. And so I'm going to talk about some holiday claims that that we've had in the last year, and we can't really start this without talking about X and Kuoni. I'm not going to go on about it at enormous length. We all know the very unusual background to this, and you know the facts on that are so specific. But the important thing is where we've got to with the Supreme Court, who have said that when you're looking at the obligations of the tour operators, of course, in that case under the old regulations, but I for one don't see a reason why the new regulations would be different, that the court should take a broad view of the obligations owed by the tour operators, and then at the same time a narrow view about the defences. And that relates to you know, the specific defence relied on in that case, but presumably the other defences as well, and that the defences can't be made out when what you're complaining about are issues to do with the supplier. So I think that does answer the question, and I'm not expecting more to give on Kuoni, but it may be that Sarah has a different view to that.
I'm told there's an argument on costs because the defendant says, well, the claimant won in the end on that interpretation, But way back at first instance, they had pleaded their case on 2 alternative grounds and they lost on one of them. So way back at first instance, they lost on one of the grounds, which means that they shouldn't get their costs back. Seems to me that is pretty ambitious, given that the reason it went up to the CJEU and back down again to the Supremes
was on these other issues.
It's all about this, yeah. So I think it's ambitious, but as I understand it, it's still open, or was last time I checked.
Well, the other case that I'm going to talk about now is the Griffiths and Chewie case, and my view is that this is a really important case, and of course the context is gastric illness claims, but the issue in the case is about expert evidence generally, not just in gastric illness cases, in fact, not just in holiday cases, but in all cases. And on the judgment of Mr. Justice Martin Spencer, brackets no relative, whenever there was an expert, then the other party, if they wanted to challenge that evidence, would have to have their own expert evidence, have some underlying evidence to challenge the premise of the report, or would have to call the expert to be cross-examined. And that would be the case even if it was an expert only reporting on some relatively small and self-contained part of the case. So the implications of the High Court decision are profound. And the result from the Court of Appeal decision is that there is no strict rule that says that uncontroverted expert evidence has to be accepted. And so it is possible for a party who wants to take issue with expert evidence to sit back, ask no questions, not call the expert, not get their own evidence, and just try and challenge the report in cross-examination. And if they do that successfully, the judge can reject the evidence. And that's very problematic itself, because it may well be that the supposed issue with the expert evidence could be very easily remedied if the expert were only asked about it. It might be a case that the experts not perhaps expressed themselves as clearly as they intended. You can have a situation where, you know, Sarah and I, as barristers, are always able to pick out some problem with an expert report. And it is unsatisfactory to have evidence being picked over and challenged for the very first time in closing submissions, when in fact, in many cases, that could have easily been addressed and remedied earlier on. In reality, what the Court of Appeal majority do point out is that whilst that is possible, it's actually a very high risk approach for a defendant to take. And it may be that that worked in Griffiths because of the particular circumstances of the case and the particular things that there were to say about the report in that case. But ordinarily, following Griffiths, I would expect a judge looking at this sort of argument to say, well, you've never challenged any of this before, and to essentially give an element of the benefit of the doubt to the expert in that sort of case, and to be quite aware of the tactical problem with just trying to challenge something for the very first time in closing submissions. But where we are with this is that a party who's putting forward expert evidence needs to be really careful to make sure that it does cover all relevant matters. It's not sufficient just to have an expert who comes to the conclusion which is the one that you need for the case. The expert's got to actually consider all of the obvious areas in the case where expert evidence is needed. So in the context of a gastric illness case, the other potential causes, how it could have happened, how likely is it to be connected with food, etc. So could it have been acquired before the holiday? The expert evidence needs to cover those, and anyone putting forward evidence like that needs to proceed on the assumption that that's going to be it for the expert evidence, because the defendant may not ask any questions and you might not have the opportunity to do so yourself. So make sure the evidence is pretty comprehensive. Also, there has to be a chain of reasoning if the evidence is going to be accepted. I think we've probably all seen expert reports where the expert's very confidently given a conclusion, but with little or no reasoning behind it. And there were lots of cases where the courts have said what matters is the reasoning almost more than the conclusion, but certainly you need both of them. And there obviously is going to be a chain of reasoning. So the expert needs to have said that. Uncontroverted expert evidence can be challenged, doesn't have to be accepted, as I've said. The defendant can, or the other party to the person tendering the expert evidence can sit back and challenge this at the end. As long as the expert's veracity or integrity isn't challenged, which is interesting because I think sometimes the sort of attacks that do get made trespass into that sort of area. And the Court of Appeal majority say there's nothing inherently unfair about that. And as I say, it might be a high-risk approach. But I've been talking about the Court of Appeal majority because there's also an extremely strong dissent. And going as far as to say that what happened in this case and what the majority is basically giving a license for is trial by ambush. And in fact, that the result of it was that the claimant hadn't had a fair trial. So that's pretty much as strong as it gets in a dissent, I think. And turning back to our crystal ball, I really strongly suspect that we haven't seen the end of this issue. But one point I would make is Lord Justice Bean in his dissent did not actually support the exact principle that had come out of the High Court decision, because he didn't agree that basically the court was stuck with uncontroverted expert evidence. He actually had a slightly more nuanced approach, which was that he wouldn't allow a challenge for the first time in cross-examination where the defendant had had the opportunity to rely on their own evidence and to cross-examine, but had chosen not to. So if that approach were to be adopted, there'd be a difference in what happens in, say, a fast-track case to a multi-track case. Because if you have a fast-track case where there's no opportunity for expert cross-examination normally, that would be different to a multi-track case where you can do that. We've had a question here about what if the defendant had the opportunity to raise Part 35 questions? And the answer is that it wouldn't make a difference. I think in Griffiths there were Part 35 questions, but they don't actually end up controverting the report, because unless the result of them is that the expert changes his mind or it gives rise to some evidential basis to challenge the report, Part 35 questions themselves aren't going to actually be controverting. So when we've been looking in our crystal ball as well, obviously something very significant that happened this year is settlement in the claim arising from the Tunisian terrorist attack. And this case has settled without any admission of liability. So we don't know how the court would have dealt with the allegations that were being made in that case. But it does give rise to interesting possibilities, as we say in the slide, because it does make you think about other sorts of cases that you could potentially bring or have brought against tour operators where what's happening are criminal acts of third parties. What about muggings, if there is a very particularly dangerous place where a holiday is happening, the extent of the obligations to risk assess and to warn travellers in that sort of situation. And bringing a claim arising out of this does give rise to possibilities of bringing other sorts of cases in situations where criminal acts of third parties and also potentially natural disasters, if there are also issues about warnings and risk assessment to do with that as well. But of course, there's been no judicial decision and no admission of fault in that case, so you can't rely on it for anything at all. But it does provide an example of widening the ambit of potential claims, I think, beyond the narrow view about things that are obviously directly to do with the package holiday contract. I'm conscious of the time, so I'm going to accelerate, but the last case that I was going to mention here is the Silverman and Ryanair case, because this is very interesting about applicable law. And in this case, Master McLeod decided that in a case involving an accident at an airport in England, where you have an English domiciled claimant. The airline was Ryanair. The contract had a choice of law clause in choosing Irish law. And Master MacLeod held that when looking at the applicable law, which was particularly relevant for quantum, this was actually a contract claim governed by Rome 1, and the Irish law would apply to it. And that's the result of the decision, perhaps surprisingly. Sarah, I think it's over to you at this stage.
Sorry, I'm gossiping with Andy Cooper. I'll stop now. Yeah, thank you, Andrew. So what's going to happen in 2022? Well, we've already foreshadowed, I think, quite a lot of what we think is going to happen. It's the Year of the Tiger, by the way. I actually was born in the Year of the Tiger. I discovered that the other day. It's quite exciting. Katie was born in the Year of the Pig, my daughter, which doesn't surprise me at all. It just shows you. Will we be joining Lugano anytime soon? Something we get asked probably every 6 weeks. I think the answer to that is a resounding no. Because, well, not just because, but partly because the presidency of the Council of the EU is now in French hands. And it was the French who objected in the first place to us acceding to Lugano. So I think with the French in charge, it is highly unlikely that that objection is going to be withdrawn, particularly given the deterioration in relations between the two countries. So no, we can't rely on Lugano. So we are lumbered with the jurisdictional rules that we're dealing with at the moment. There is no point waiting until Lugano comes in, I think, because it's going to be some considerable time. There just doesn't look as if there's any movement here. So as a result of that, we're going to see more of these claims that we've been talking about, the consumer, the employment claims. I'm thinking particularly things like cosmetic surgery, cross-border clinical negligence. There's been loads of those at the moment coming in, of people who are going to Poland to get their teeth done, they're going to Turkey to get their bottoms done, they're going to Romania to get their breasts done, and they're coming back and it's not gone well. So those claims we can bring within this jurisdiction because of the amendment to the Act. So seeing lots of them, employers' liability claims the same, as people have moved out to do jobs abroad more often, or as the world is becoming more peripatetic, seeing lots more employers' liability claims, although not arising in the last couple of years. Are we going to see claims for failure to risk assess, warn and keep employees safe? We're seeing more of those, seeing quite a few. I mean, Afghanistan's going to give rise to a number of those, of people. I mean, one of my friends got stuck at Kabul airport because he was working in security for one of the oil companies. And it sort of looked for a while as if they weren't going to get them out. Is there a failure to risk assess? Is there a failure to warn and to keep them safe? We knew when we were withdrawing. So did employers fail to give any thought to how they were going to get their employees out? So we're going to see a lot more of those, I think. And they can be brought here, as I say. We know we're going to see some jurisdictional challenges to do with residents, to do with foreign convenience, to do with the ambit of those consumer and employer jurisdictional provisions. We're already seeing them. We're seeing a lot more arguments around anchor defendants as people try and bring more and more defendants in, anchoring them with English defendants. We're seeing lots of cases arising, as we said, out of extensions of time for service and methods of service. I think as we use the common law rules more, we become more confident in using them. So we're going to start to look at serving in different ways. That's one of the things that we did in the on the beach case, the Ali Balogun case, use different methods of service because it was quicker and easier to do it that way and more cost effective. So I think we're going to see people using different methods of service because we're looking now at serving outside. We're also going to see some Euro legislation certainly reviewed. Are we going to see it binned? The government has already said they're going to bin Vnuk, but there's no sign of them binning the applicable law rules under Rome's 1 or 2. And it's quite interesting that although the government committed itself to binning Vnuk liability, you know, this liability for motor insurers on private land and so on and so forth, the government's not actually doing it. So they said they'd bin it, but the actual binning itself is being done by way of a private members bill, which is introduced by Peter Bone MP, who is very Eurosceptic, quite hard right, and an erstwhile sponsor of a bill to rename the August bank holiday after Margaret Thatcher, which failed. So it may or may not be that the motor vehicles compulsory insurance bill is going to pass. It certainly doesn't have the government's imprimatur, although it has gone through committee and it is now going through the Commons. It looks as if it's going to pass and we're going to bin Vanook without really having a discussion about it in the Houses of Parliament, or without the government actually implementing it themselves, which is perhaps surprising for something which causes divergence between us and Europe. Although, as I said, Europe is itself rowing back a bit from the position on Vanook as we speak, because they've just done a directive on that. A number of procedural and evidential issues remain outstanding. Andrew, I think you know all about these, or know more about these than I do.
Well, yeah, so we referred to Griffiths already. And in terms of procedural and substantive law and interest, well, we've got conflicting decisions about this. And which is the case and which interest you apply can make an enormous difference in some cases, particularly these Spanish ones. And the position at the moment is pretty unsatisfactory, it seems to me, for being able to advise clients about what's likely to happen because of conflicting case law. So I would agree with Sarah that looking in our crystal ball is going to be more to watch on this issue. And the other thing that we wanted to talk about on here was expert evidence about quantum and how is that working? Now, really, I think, I'm just looking at the time, I think this is probably an issue for a whole webinar, Sarah. But it does feed into the Griffiths point, I would say. And when I was talking about Griffiths, following where we were with the Court of Appeal, I was saying the party putting forward the evidence needs to make sure it covers all of the relevant matters. And chain of reasoning needs to be given, bearing in mind that the evidence can be challenged later on. And I would think about that when you're looking at foreign law evidence. So particularly if you've got a foreign lawyer who disagrees with the other expert, they need to really explain why that is. And they need to make sure that they've given in their own report the reasons for the conclusion. It's not sufficient just to say, it's this. You actually have to have a chain of reasoning. And similarly, if they've had input from somebody else, so let's say a foreign medical expert to translate the reports, as sometimes happens, it's going to be the lawyer's evidence. And the lawyer needs to give the chain of reasoning and can't just say it's this because that's what the assessor has said. I don't know if there's anything you want to add to that, Sarah.
Yeah, and I think that's right. And I think it's very, very difficult. I'm not sure that Wall is working terribly well. And I think it needs to be revisited, and probably sooner rather than later. It's always French experts that cause the problem, because there's this chain between medical expert and lawyer, and there's this bridge of sort of saboteur. And unless that person gives a CPR compliant report, you can't Part 35 them.
Well, I think we should maybe give a whole webinar on this issue, because it is really complicated. So if people would like that, then let us know.
Yeah. Anonymous attendee asks, have you seen an increase in parties instructing a French medical expert? Does this not contradict Wall? Yes. Should this be opposed if the defendant requests permission to instruct the same? Your problem may be that if you're for a claimant, your expert may be saying the same thing. So if ever I'm for a claimant and my French law expert says, I need this bridging report, then fine, we both need it. But my preference is always going to be to get a French expert who doesn't need a bridging report and just relies on the English medical evidence.
In theory, you should be able to have questions to the English medical experts that will enable the French expert to answer this. So, if somebody could actually explain the concept of consolidation in a clear way, then we could put that to the English medical experts who'd be able to say. And I think that's really what the challenge. That's what the challenge is. But somebody, Nick has said in the chat that judges tend to give permission for the French assessors, notwithstanding Wall. And
yeah, they do.
They don't always, but they tend to. And it's normally, I think, that judges just want to deal with this in a pragmatic sort of way. And if we're in the situation that Sarah's just said, where the French law experts say, look, we can't actually do our job without this, then it's going to be very difficult, to get the evidence at all without it happening. So I think it's a case of sometimes attempted pragmatics trumping the strict decision.
Yeah, I mean, I think my preference would always be to get a French expert who can actually do the job you want them to do, which is to do it without this bridging report. Chris says that Master Davison dealt with this in an unreported case of his, which I've asked him about. Just while he does that, let's move on and just to polish off our predictions, so I'm conscious of the time, and we have kept people for longer than we ought. Cancellation claims I spoke about, there's some quite high value ones knocking about out there. We're going to get some guidance on that this year in relation to cancellations, but we can also expect to see some Section 75 guidance. We had last year some guidance on whether the cardholder has to be the claimant in a Section 75 claim, to which the answer is yes. That's due to the provisions, I think it's 119 of the Act itself. So the claimant must be the cardholder. They can't claim on behalf of one or the other. But there's going to be more of these coming through because there's going to be more insolvencies, I'm afraid. And then, Andrew, just in relation to holiday claims, whilst I read what Chris is putting.
Yes. So because we've had so many fewer holidays in the last couple of years, the number of new claims obviously going to reduce in the short term. Hopefully bookings are going up and there's going to be a lot of making up for lost time now that we can travel more easily again. But I think one of the main points is that the new package travel regulations still are quite new and remain pretty untested. And there's a lot of scope for decisions about really how these work, how the defences work, and the various definitions in there, particularly when they're different from the old regulations. We've talked in previous webinars about the flicker of hope test, for example, and these are to a very large extent issues which still remain to be determined by higher courts. So there are going to be cases that deal with these.
Yeah, I agree. And then the most important thing that's going to happen this year is, of course, and I know you've all been waiting for this, is the new edition of Status on Travel Law and Litigation. And that was the only picture I was able to find of Alan. I couldn't find one of him in his full-bottomed wig. So he's gazing longingly at the last edition. And we've all been beavering away on the book. I know, save up your pennies because it'll be out probably this summer, I think, at which point we are likely to do a road show with cardboard cutouts of all the authors and rare unsigned copies being available. So that's the most exciting thing that's going to happen this year. If you would like to stay for any further questions about anything, then please feel free to do so. We're here all day to answer your questions. Otherwise, I'm sorry we kept you for a little longer, but I do think that 2 years worth of travel law in an hour is actually...
and the future predictions and the Madame Arcadi predictions of what's going to come as well.
Exactly. Right, any other questions, or shall I draw us to a close?
Thanks very much to everyone for the questions and comments in the chat. They make a really big difference to how this goes and the discussion that we have. So very grateful to people doing that.
Also, I learned something today. I learned that you have to make an application for default judgment. So thank you to Catherine and Christine and to whoever it was that answered the question. That every day's a learning day, isn't it? Thank you all.
Thanks very much.